A very good morning to all my dear students. Today we are going to discuss about the concept of review as provided under the Code of Civil Procedure. My dear student, this is the one of the topic mentioned in the unit number 4 of the syllabus. Before this, we had already read about the concept of appeals. Thereafter, we had also read about appeals from original decree as well as appeals from appellate decree and general provisions as to appeal. Thereafter, we had also discussed about the concept of reference. Now we are going to discuss about review. Section 114 of the code provides this substantive right of review in certain circumstances, and Order 47 provides the procedural right thereof. The provisions relating to review constitutes an exception to the general rule that once the judgment is signed and pronounced by the court, it becomes functus officio, meaning thereby it ceases to have control over the matter and has no jurisdiction to alter it. So this is one of the exceptions wherein the same court may alter its judgment even after the judgment has been pronounced by it. Next, as far as the meaning of review is concerned, the said word has not been defined in the Code of Civil Procedure. My dear students, as you all are aware that various expressions has already been defined under section 2 of the Code of Civil Procedure, such as judgment, decree, order, foreign court, foreign judgment, but the legislature did not provide the definition of review at that material time while enacting this particular code of civil procedure. For this, we have to look at Chambers Law Dictionary, 1997, page number 1197, wherein the word review means to reconsider or to look again or to re-examine. In legal sense, it is the judicial re-examination of the case by the same court and by the same judge. In review, a judge who has disposed of the matter reviews an earlier order passed by him in certain circumstances. Now we will go further and discuss about the nature and scope of review. The normal principle of law is that once a judgment is pronounced or order is made, the court becomes functus officio, meaning thereby such order or judgment becomes final and it cannot be altered or changed. A review of the judgment is a serious step, and reluctant resort to it is called for only where a glaring omission or a patent mistake or like a grave error has crept in earlier by judicial fallibility. The power of review should not be confused with appellate powers, which enables an appellate court to correct all errors committed by the subordinate court. Meaning thereby, this provides the difference between the power of appellate court as well as of the reviewing court. My dear student, as you all are aware that the appellate court can re-examine all the points which have been mentioned or given or explained in the impugned order. Next, what is the object behind review? The review, remedy of review, which is a reconsideration of the judgment by the same court and by the same judge, has been borrowed from the courts of equity, meaning thereby this principle has emerged from the courts of equity in England. The concept was not known to the common law. The remedy has a remarkable resemblance to a writ of error. The basic philosophy inherent in the recognition of the doctrine of review is the acceptance of human fallibility, meaning thereby, if there is an error due to human failing, it cannot be permitted to perpetuate and to defeat justice. Such mistakes or error must be corrected to prevent miscarriage of justice. Now we will go further and discuss about the circumstances for review, meaning thereby when review lies. A review petition is maintainable in the following circumstances or in the following cases. Number one, cases in which no appeal lies. Where no appeal is allowed to an aggrieved party, he can file a review application. When an appeal is dismissed on the ground that it was incompetent or was time barred, the provision of review would get attracted. Second, right of appeal lies but not availed. My dear students, to this I would like to submit that a review petition is also maintainable in cases where appeal is provided, but no such appeal is preferred by the aggrieved party. An application for review can be presented so long as no appeal is preferred against the order. However, when appeal is already pending in the court, no review can be entertained. But if the review petition is filed first and subsequently appeal is filed, the jurisdiction of the court to deal with the review application is not affected. Now, I just want to apprise you the points or the grounds on the basis of which a law student or a lawyer can file or draft a review petition. Number one, there must be a discovery of new and important matter or evidence, meaning thereby a review is permissible on the grounds of discovery by the applicant of some new and important matter or evidence, which after exercise of the due diligence was not within his knowledge or could not be produced by him at the time when the decree is passed. The underlying object of this provision, my dear student, is neither to enable the court to write a second judgment nor to give a second innings to the party who has lost the case because of his negligence or inadvertence. Next, there must be a mistake or error. What is an error apparent or on the face of record cannot be defined precisely or exhaustively, and it should be determined on the facts of each case. Such error may be one of fact or of law. My dear students, no error can be said to be error or said to be apparent on the face of the record if it is not self-evident and requires an examination or argument to establish it. In the case of Tungabhadra Industries Limited versus Government of Andhra Pradesh, AIR 1964, Supreme Court 1372, wherein the Supreme Court observed that where without any elaborate argument one could point to the error and say, here is a substantial point of law which stares on one in the face, and there could reasonably be no two opinions entertained about it. It is a clear case of apparent on the face of record would be made out. And the third ground on the basis of which a review may be filed before the same judge is that there must be any other sufficient reason. The expression other sufficient reason has not been defined in the court. There are reasons which has been observed in a number of cases as other sufficient reason. Number one, where the statement of the judge is not correct. Second, the decree or order has been passed under a misapprehension of true state of circumstances. Number three, where a party had no notice or fair opportunity to produce his evidence. Four, where a court has failed to consider a material issue, fact or evidence. Number five, misconception by the court of a concession made by the advocate. And the last one is the court has omitted to notice or consider material provisions or material statutory provisions. So these are the grounds, other sufficient grounds on which a review may lie. Now, who may apply for review? A person aggrieved by the decree or order may apply for review of judgment or order. Now, what do you mean by a person aggrieved? A person aggrieved means a person who has suffered a legal grievance or against whom a decision has been pronounced which has been wrongfully deprived him of something or wrongfully refused him something or wrongfully affected his title to something. By whom a review may be made. It may be made by the same judge, but there are certain exceptions in which the same judge is not available, and one of the circumstances that due to the death of the judge itself, then what would be the remedy? Then his successor or any other judge or other court of concurrent jurisdiction may hear the review petition and decide the same. Is there any format of application? As far as the law pertaining to the same is concerned, the same has been provided under Order 47 Rule 3, which provides that an application for review should be in the form of memorandum of appeal as mentioned under Order 41 CPC. What is the procedure at hearing? While procedure at hearing for review, it may be divided into three parts. Number one, first stage is ex parte. In this, then application for review commences ordinarily with an ex parte application by the aggrieved party. In this, the court may reject it at once if there is no sufficient ground, or may issue a rule calling upon the opposite party to show cause why review should not be granted. Second stage, it is to be heard by the same court. The application for review shall then be heard by the same court and by the same judge who passed the decree or made the order, unless he is no longer attached to the court or is precluded from hearing it by absence or by any other cause for a period of 6 months after the application. If the rule is discharged, the case ends and the application will be rejected. If on the other, the rule is made absolute, the application will be granted for rehearing of the matter. And the third stage, in the third stage, the matter will be reheard on merits by the court either at the once or at any time fixed by it. After rehearing the case, the court may either confirm the original decree or may vary it. Now the next question is there any time period? Yes, the time period for filing a review application is 30 days, and this 30 days needs to be computed from the date of the review or the order. What is the remedy against the dismissal of the review application or petition? The remedy is the filing of an appeal. An order granting an application for review is appealable, my dear students, but an order rejecting an application is not appealable. And the limitation for this is also 30 days. So this is all about, my dear students, for today's topic. Hope you have learned a lot out of it. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on revision, and the relevant provision which needs to be read for is section 115 CPC. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.